Welcome back to Law News Network. I'm Heather Hansen, and we have a fabulous guest here with us via Skype. His name is Stephen Mulroy, and he's got the whole gamut covered. He is a former federal prosecutor. He is currently a criminal defense attorney, but he is also a law professor at the University of Memphis. Good morning. It's still morning. Good morning, Stephen.
Good morning, Heather. How are you doing?
Very well.
I don't do as much defense practice anymore because now that I teach, but I have done some in the past.
And teaching is certainly an endeavor in and of itself. I'm sure that you answer your students' questions just as you'll be answering my questions and hopefully the audience's questions as well. Thank you for being here with us.
My pleasure.
I have a lot of questions for you. And one of the first ones I think that I want to talk about is we've now seen Toledo, the defendant, speaking to the police officers on two different occasions, two different interviews, and in many ways it's almost as if he is testifying. It doesn't seem to be helping him a whole lot, but given that he has now put out these various stories in front of the jury, do you think that that makes it more or less likely that he will testify on his own behalf in the actual trial?
Well, normally the cautious thing to do would be to not have the defendant testify because he opens himself up to cross-examination.
Right.
You know, particularly if there's anything in his background that could be brought up that would impeach his credibility. But in a case like this where the evidence does seem somewhat damning, it might be that's the only way out. I mean, you know, at a certain point when the situation is desperate enough, then you try anything. And I think it might be the case in this situation that the jury needs to hear from the defendant. They need to hear him personally say his side of it, and that might be the only chance for getting reasonable doubt here.
Yeah, I agree. I agree with you that desperate times call for desperate measures, but it's such a risk here because there's so many inconsistencies in his various stories, and he's given so many different stories. And then add to that his background. I believe he was a member of a gang. As you pointed out, Stephen, that type of information about Toledo may become fair game if he testifies, right?
Yes, that's right. And now, of course, if it's not an actual criminal conviction, if it's just prior bad acts, then there's a whole evidentiary rule about that. And, you know, it's not clear whether it would necessarily all come in. But as you pointed out, it nonetheless still is a very, very big risk, particularly with all the inconsistencies in his testimony. Just my own personal view is, as bad as the evidence seems to be, it might be the only thing for him to do.
Yeah, and it's an interesting situation because this is a death penalty case for the death, the alleged murder of the two children. And if he is convicted, we will go right into the penalty phase. Those are those two adorable children that he is accused of having murdered. You know, if we go straight into the penalty phase, I think that we can agree that we would expect to see him testify in that phase at the very least.
Oh, yes, I know, absolutely. I mean, because then things about his background and hardships that he had growing up, or you know, any remorse that he might feel, any of that kind of stuff becomes something that he can personally say to the jury, you know, for the sentencing phase, and I think that's important.
Now, the other thing that I have been thinking about, and the people in the chat room have been pushing back because they feel as though Toledo clearly committed this crime, these crimes, and that he is trying to pass it off and try and pin it on his neighbor Tyshaun Jackson.
Right.
Jackson comes across, Stephen, as such a likable witness, and he teared up when he was talking about the death of the children. I think that the majority of people who have watched him testify find him to be extremely credible and likable. And now you've got the defendant, who we're now looking at on the screen, trying to pin not only a murder, but murder of two children on him. As a defense attorney, would you be concerned that that defense, that plan, could actually hurt your client in the death penalty phase? Because trying to pin this terrible crime on someone who comes across so innocent and likable.
Right, and Heather, that's a dilemma that criminal defendants have in lots of cases, including this one. If you deny responsibility and you take the stand and you testify to that effect, then, you know, at sentencing, you don't get credit for acceptance of responsibility, which is a big, you know, thing to consider in sentencing. And also you might get, you know, demerits, if you will,
right,
for having lied in your testimony, having perjured yourself during the trial. All of those things are even more at issue here, as you point out, where he might be found later on to have falsely tried to pin it on a very likable witness. So it's a risk.
Let's talk a little bit about Jackson, because in my practice, the majority of the time, if the prosecutor calls a witness and I take the opportunity to cross-examine that witness, I then don't have the opportunity to recall that person in my case. However, here, that is going to happen, and I think that you've said that that's consistent with what you've seen in your practice.
I have seen that in my own practice, and I think this is a matter that varies by jurisdiction. I think some allow it and some don't. Mm-hmm.
And so it really is a wonderful opportunity for the defendants, the defense attorneys, because now you've got Tyshaun Jackson had testified. He was the first witness, and I think let's talk about that a little bit. When you've got the person who the defendant is going to try to pin the crime on, and that person happens to be likable and credible and make a good witness, it certainly makes sense to call that person first, to set it up straight out of the box that this is the guy who we're talking about throughout this entire trial, don't you think?
Yes, I do. I think that makes sense. I mean, you want to make it as presentable and digestible as possible for the jury. Yes.
And now, so they put him on, he tells his story, the defense attorneys do have the opportunity to cross him, but now, by the end of the prosecutor's case, we will have heard from the deceased woman's mother. We will have heard from the DNA evidence. We would have heard from Toledo himself through these interviews. And now the defense gets to call Tyshaun Jackson and really, if they want to, go after him. It's a good opportunity for them, isn't it?
Well, I think so. Yeah, I think it would be a good opportunity for them. And given that this is a so-called Plan B theory where you're trying to pin it on somebody else and you have another suspect, the opportunity to call that suspect and cross-examine him, I think it's crucial, really, to the theory of defense that they've chosen.
Yeah, and it seems as though it's sort of a Hail Mary. It's what they have to, between that and perhaps, as you said, calling Toledo himself. I mean, those are the things that really have to go well for the defense in order to have any chance of escaping a conviction, wouldn't you say?
I think that's right, and you said it before, desperate times, desperate measures, but I always say in these cases that all it takes is to plant some reasonable doubt in the mind of one juror.
That's right.
That's all it takes, and it's possible that the combination of the testimony of those two people might accomplish that.
Yeah, it's so hard, when you're defending a case, you often during your opening will beseech the jury to not make any decisions and not come to any conclusions until you have the opportunity to present your case. But here, especially because the jury has heard from the defendant for so long, I mean, these
Right.
interviews with him are so long, it's
Right.
really especially hard for the jury not to have made up their mind, don't you think?
Yes, and in fact, Heather, there's extensive empirical studies and evidence about particularly false confessions that show that the power of a confession, a videotaped confession, or even audio taped confession from the defendant, how powerful that is on the jury. I mean, it's often unrebuttable. Even in cases where there might be significant evidence that perhaps the confession was coerced or the person was under undue influence of some kind, that kind of argument that it was coerced or undue influence becomes even more difficult if you have multiple videotapes of the person confessing. So I think all of that evidence showing how powerful that is on the mind of a jury makes it extremely difficult for the defense to mount a convincing case once the jury has already heard that.
I agree, and I think that it's also a really difficult case for the defense attorneys when you've got two children who have been the victims of the alleged murder. How do you think that you can overcome, if it's even possible, the enormous sympathy factor, and not only the sympathy factor, but when we get to, if we get to the penalty phase, the anger factor with murder of children as young as these? Is that something you can overcome, or is it something that you have to just work around the sympathy in the jury's minds?
Well, I think in the guilt phase, that might be where the testimony of the defendant would be of some benefit. I mean, the defendant could get on the stand and testify about how heartbroken he is
Right.
about the death of the children, and evoke sympathy on his own, but just argue that it wasn't him that was responsible. I think that can be difficult sometimes because it's so emotionally powerful, but at least there's a coherent argument there, where a defendant could make a convincing case that he's just as broken up about the death of the children as anybody else, and he would like to see justice done for the real killer, who is not him.
Right.
But once you get to the penalty phase, it's very difficult indeed. I mean, in fact, the vulnerable victim is one of the listed aggravating factors that most jurisdictions use as an aggravating factor militating towards the death penalty.
Right.
And here we have not one but two vulnerable victims.
Yeah, it's and I can see that in the people on the chat rooms. The level of frustration and anger and sadness is higher when it's children. And in so many of these cases, it seems that there are children involved. I do have a question for you, Stephen, about the fact that there's no bodies have been recovered. When you have a situation like that, isn't there an inherent piece of reasonable doubt as to how the children were killed, where the children could be, and whether in fact, I mean, the defense has been, at least with the judge, been making the argument that there's no proof that the children are actually not alive somewhere. So how do you, as a prosecutor, overcome that little piece of reasonable doubt?
I think that's a fair question to ask. It's the kind of thing that might go through the mind of a lay juror. Some laymen may have heard this corpus delicti phrase, like, do you actually have proof that the victim is dead? But I think we can easily make too much of it. I mean, the standard is proof beyond a reasonable doubt, not proof beyond all doubt. And, here we are months and months later. The children haven't surfaced. There doesn't seem to be a plausible narrative for why the children aren't around. And I think it's entirely reasonable to conclude that they, tragically are in fact dead. So I don't think you can make a per se rule that the lack of a body leads to reasonable doubt. I think jurors are allowed to use their common sense and make reasonable inferences from the fact that they're not around. No one can find them. It's been a while. Something must have happened to him.
Now, one of our chatters, TP, just made the point, and I think it's a good one, that if there was any real motive for Jackson to have killed the children, then perhaps Toledo's story would be more believable and more easy to sort of grab onto. Though it's true that you don't need to have motive in these cases to establish guilt or to establish the case on either side, it certainly helps for the jurors to be able to say, well, Jackson might want to kill the children because of X, Y, and Z, or Toledo might want to do so because of X, Y, and Z. Do you think the lack of motive in a situation such as this could be the thing that makes the defense's theory sort of fall apart?
Heather, I think you're onto something. I mean, it's up to them, I think, to plant a seed of reasonable doubt by constructing some sort of plausible narrative whereby this other person might have committed the killings. And if they don't even have an articulable theory grounded in at least some evidence as to some sort of motive, then it doesn't seem at all likely that the jury will buy this.
Yeah, I mean, the story is, when you're a defense attorney and you only have so many things to go with, you sort of take what you can get. But this story seems to be very little to take and very little to get.
Right. I think that's a good way of putting it.
Well, Stephen, I want to thank you so much for being here with us and discussing this case. I know that it's one to watch, and we'll continue watching, and it's certainly a difficult case for the defense side. But we appreciate you being here, and I'm sure we'll have you back again soon.
Thank you very much, Heather. Thanks for having me. Take care.